I didn't include it in the charges, but I let the attorney argue it in closing. And of course say that Georgia law allows you to blah, blah, blah. And then they have your argument and they have that statement, which is an accurate statement from you. And then they have the law that I give them, and then they put the whole thing together. And so that is exactly what we did. It took me a second to put it all back together. So I'm not comfortable deviating too far from the pattern on that, but you can argue it, and you can of course say Georgia law, or there's however you want to phrase that so that it's appropriate, because it's not technically Georgia law; it's in court interpretation. And as long as you're anywhere within that ballpark, I'll let you say it the way you want to say it.
And just to be clear, I would most likely say Georgia courts have ruled.
Good answer. That's it. So, all right. I think that would work great. Mr. Ison, do you want to speak into that at all?
No, Your Honor. I believe that's correct determination.
Okay. All right. Perfect. All right. So do we, so obviously those charges are not the final charges. This is kind of like this is our charge conference, but obviously we have a few more items to cover. Does anybody else want to cover the jury charges or anything else before we pivot to my next topics?
One more thing, Your
Yes.
Honor. I don't know if I know the state has not yet rested yet, but I expect them to rest. And then of course we were going to the defense's portion. I was wanting just for the purposes in that portion, just to introduce the disposition from the Brookhaven Municipal Court. I do believe it is a self-authenticating document. It has come attached with an affidavit of authenticity. And I do believe that it is a hearsay exception due to the fact that it is a business record. So I just want to make the court aware that that's what I was intending to do, and to talk about it beforehand to make sure that there's no issues when it gets to that portion of the case.
Okay. All right, go ahead and show that to Mr. Ison. Make sure he's got a copy. If you don't have an extra copy, Margaret's coming up to make a copy for you.
And I do have an extra copy. This one also has the exhibit sticker on it.
Oh, you've already got it. Okay.
Oh. Now that one looks bad. That's just gonna.
Your Honor, I had never intended to introduce this in the first place, particularly because I didn't have a certified copy. But if it is for the record, the state does object to it. But if it is let in, I would say that it be let in and allowed to be described as plea negotiations, because looking at it, it's fairly obvious that is what happened.
Okay. All right. So our steps that will follow in just a few moments when we become very formal and in front of the jury is going to be that we'll come out. I actually have an announcement. Instead of doing the 403 balancing test every time something's come in, I just do it at the end of each phase. So I'm going to do my 403 balancing declaration, because I have to do it for the independent evidence as well as the exhibits and everything. I'll then ask, I'll do it in reverse order this way. So I'll go to the defense first and go, do you have anything else, before I ask the state for their announcement on where they're at? That's when you'll tender that as certified and self-authenticating. The state will object. I'll let it in over the state's objection. That way we all know where we're at, what we've got. And then, but I'll go ahead and say that when you all have that there at closing, Mr. Ison will have full authority to describe it exactly as it is. And we will not get into, I'm not going to limit anybody's discussions of pleas, trials, bench trials, jury trials. The jury deserves a very accurate discussion of what that is and how it got here. And so I'm just letting everyone know that I will let that be handled pretty freely in closing when you all are discussing it with the jury.
Understood, Your Honor.
All right, and then you'll rest.
Judge, if I'm just in order to get things straight, after you talk to the jury about all that, he's gonna tender that as defense exhibit one with no witness. Okay.
Because it's certified, right?
Yes.
Yeah, so
Well,
certified,
there's a copy of what's known as a
It's an affidavit of authenticity.
affidavit of authenticity.
that's good enough. So, and then Mr. Ison, you'll be able to unpack it for the jury as to what it is and what you think it means in the same way Mr. White will have that authority as well.
And Your Honor, just doing the defense's state in chief, I also plan to publish it to the jury and then, or would you want me to just do that during closing?
Without a witness?
Normally, I would allow publication at the time of tendering. I just was planning on keeping moving. Let me think about that just a minute, because the answer is, I'm okay with you publishing it. We're about to pivot to something else and I want to see where that fits. And so I'll find a place for you to be able to do that.
Understood.
So, okay. So let's talk about the defendant. So the state rests, and normally we'd have this moment then, we're having it now. Does the defense anticipate, given that the state is not going to call any other witnesses, correct, Mr. Ison?
Correct.
All right, well, let's go ahead and do it. Do you have any motions that need to be heard?
No, Your Honor.
Okay. All right. So no motions for the defense at the close of the state's case. I know we're doing this out of order, but I'm making that the decision right now. We're done with that unless you have something else to discuss. All
No,
right.
Your Honor.
All right. Let's talk about the defendant's testimony. Have you discussed with your client, his right to testify versus his right to remain silent?
Yes, I have, Your Honor.
And Mr. Stringer, I'm going to remind you that I placed you under oath yesterday morning. Do you understand that?
Yes, Your Honor.
Okay. Do you know, Mr. White, whether or not you and your client intends to testify?
He does not intend to testify, Your Honor.
Okay. Do you intend to call any other witnesses for the defense?
No, Your Honor.
Okay, which means that we're about to rapid fire jump through this. All right, then what we're going to do is I'm going to put a little bit more on the record on that. Mr. Stringer, you understand that you have the full right to testify as well as the full right to remain silent.
Yes, Your Honor.
You understand that if you use that right to remain silent, there's a charge in the charges that I gave your attorney yesterday called defendant's election not to testify, protecting you from any negative inference on that.
Yes, Your Honor.
And you understand that you have the right to testify.
Yes, Your Honor.
And that if you choose to testify, you'll come up here and Mr. Ison will cross-examine you after Mr. White asks you your questions.
Yes, Your Honor.
And if you have any other questions on that, you're welcome to ask me, or obviously speak more with Mr. White. And is he correct in that it is your decision not to testify in this case?
Yes, Your Honor.
Do you have any questions, concerns, or anything else that you wish to address with the court on that issue before I move on to the next issue?
No, Your Honor.
Okay. All right, that'll work then. All right, well then, I think we have our orders. That gives you all 15 minutes now, if we go off record, for y'all to kind of start getting your closings kind of organized, because it looks like we're going to pivot decently quick. We do not have to start at 9:30. So if you all, it's important to me that you all have a few minutes to get all your notes and everything organized, because I'm not hearing any more witnesses. We have one more exhibit, and then we'll do a little bit of our kabuki theater moments as we walk through those processes. And then frankly, we'll do closings.
Judge, if I may have just a moment, regarding the document Vince's come up with.
Yeah, actually, I should see it. If Mr. White, will you walk it up? All right, go ahead.
It appears, and I want to make sure this is correct before I get in the arguments about it. It appears on this sheet that in disorderly conduct, a plea was entered, a no low contender plea was entered to disorderly conduct with a fine of $500. It also appears that on obstruction and interference, a null pros was entered on the obstruction. So I just want to make sure. It sounds like I'm repeating the obvious, but I just would like to put it on the record that that is what it says. So when I start arguing it, there's no questions about it.
All right, Mr. White, that's what I'm seeing. Is that what you're saying?
That's correct, Your Honor.
Okay. All right, that's my understanding as well. It seems to say that there was 2 days to serve on there. Is that right?
That is correct.
Okay, just, again, I'm not familiar with their sentencing sheets.
And I'm aware of that being on there. I'm also aware of any potential issue that may cause Mr. Stringer I believe given the evidence in this case that that's not likely to hurt him.
Yeah. Well, I cut you off. I'm so sorry. I'm sorry, Kathy. Go ahead.
Yes, the defense is aware of that and would be tendering the exhibit in its entirety.
Okay. All right. All right. Well, then actually, I'll just go and do the balancing test now. So ready? I'm just going to go ahead and rule that of all the exhibits that have been placed in the record, both for the state and the one that will be in the record in a few minutes for the defense, that the court finds that the mandatory 403 balancing test has been completed and conducted fully, and that the relevant evidence shall be admitted. The court finds that the probative value of these items is substantially outweighed by any danger of unfair prejudice, confusion of issues, misleading of the jury, undue delay, waste of time, or needless presentation of cumulative evidence. And that includes the other act evidence, which was also part of the three-part test I've already ruled on. All right, I've done that part. I'm checking that off my list.
Your Honor?
Yes.
You said entered into its entirety. The entirety also, I believe, would include the accusations from there, where we have one charge of disorderly conduct here and one charge of obstruction and interference, where they were both charged. So I would say if we're gonna do it and introduce, I understand that's been admitted, but I would also argue that the accusations be admitted as well.
All right, show that to Mr. White, and then y'all talk it through off record, see if y'all can come to a negotiation.
Yeah. Just show-
For the record, Your Honor, those were served as a packet
Okay,
to the defendant.
that makes sense. All right, we're off record for a minute while y'all talk.
Discussed it. I'm not gonna speak for the defense, but I don't believe they have an objection to it. Like I said, it's just the accusation of what's pled to there.
Okay, so what we'll do is we'll call, y'all have the original certified of the Brookhaven Municipal Court final results and the affidavit. So that'll be D1. And then since that's technically the state's addition to it, I don't want to attach it to yours because it's not yours in the way you put it in. So that means we're gonna now put a state's six.
Six, try to get to
Six.
yes, or six.
Okay. All right. So Mr. Austin, come on up and get that stamp and. Let me see that real quick. No, that's it. I see. Okay.
Good start.
That's fine. You give it back to Kathy. Okay. Do y'all need anything else before we go off record? Let you all start getting your brains kind of sorted out for closing.
Nothing from the defense, Your Honor.
All right. Anything else, Mr. Ison?
That's fine, Your Honor.
All right. So we're off record. We're not going to start right at 9:30. I'm going to start as soon as you two tell the bailiffs that you've had the time you need to get organized for your closing. And they'll go from there. I just realized I am out of my stack of final dispositions. Do y'all have a final disposition? Can't, I think I might have some back in the back since I'm responsible for ordering them, but I don't have any up here. Okay, I do need one then. So whenever y'all come back, don't run, just when you wander up, wander back. Just bring me a couple, because I always keep a couple up here and I just realized I don't have any. All right, that's it. We're off record. Y'all let me know when you're ready. And Margaret, when the jurors get here, they can come in.
Yes, Your Honor.
Yes, Your Honor.
Okay. So. All right, so the most pressing issue is that the jurors were supposed to be here at 9:30. The vast majority of the jurors were here at 9:30, but we are missing a juror, which is, I don't have my list.
Westmore.
Westmoreland. Sorry, I'm just realizing. I think I left that here with my list. This is why everything in my life is clicked hooked to me, because I would forget everything. So my glasses are hooked to me, my keys are clipped on me. Everything's clipped on. All right, so going back on record, our missing juror, all right, so with that said, we'll move forward until we bump into that moment, and then we'll push on through it. Each of you have your copy of the jury charges. I have learned the hard way to do this, which is that in the bottom right corner, you will see it says Virgin. It says 2026, 8/18 at 9:43:13 a.m. If you have something that says other than that, you have the wrong version. So did y'all say that?
Yes, Your Honor.
Yes,
All
Your
right.
Honor.
Again, I've had that go very wrong and it was my fault, and I've learned not to let that happen again. You also have a copy of this. Again, if you, this being the verdict form, if you wish to display any of these to the jury at any time, you certainly can. If you want to use the document camera to fill it out, some folks do that. There's no pressure for you to. I'm just letting you know those are y'all's copies to do with as you see fit, and they'll go with you. Mine up here, when I finish reading them, I will then, the last thing I will do will be to sign the back page. And then this, what I have in my hand, will go out with the jury for them to use in their deliberations. Anything else on the jury charges or the verdict form?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Okay. So we have that covered. In just a minute, we'll bring the jury out. Once we get some sort of confirmation from the clerk's office on their attempts to check, I'll actually go to, just to make it certain this is clear on the record, I will go to the defense first. Actually, I'll go to the state first and say, do you have any other witnesses? You'll say no. I'll pivot to the defense and then go, do you have anything before we close it out? You'll tender yours, you'll object. We've covered that, and that way I'll enter it. And then I'll say, Mr. Ison, do you have anything else? you'll tender yours, you'll object, and I'll put it all in. Or however, I don't remember if you were objecting or not. But if you are, that's fine. And then you'll rest. And then I'll ask the defense, do you have anything? You'll say no. And then we'll pivot straight to closing. Does anybody have any issues with that or anything else?
No, Your Honor.
Okay, well then, let's just take about 5 more minutes. We're just gonna sit tight, let the clerk's office, yeah, you're good to go. So we're all just gonna sit at ease, off record. If you need to use the restroom or anything, feel free. And then as soon as we get that answer from the clerk's office, we'll jump in. All right, let's go back on record. All right, so what we're going to do is, with our missing juror, we've made a good faith effort now. It's now been 45 minutes since he was supposed to be here. We've not been able to have contact with him. The email has not been answered to our knowledge. That's all right. Phone calls have not been answered. There's no voicemail option. We're all very surprised he's not here, but the fact is he's not here and we're now 45 minutes behind where I wanted us to be. So I'm just going to put it formally on the record that I'm moving. Let's do this the right way. I'm releasing juror 42 Westmoreland and replacing him with juror 72 Childress. And that's going to be our 6-person jury. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
All right, well, then that's the decision, and we officially have our jury back in place. Everybody has their jury charges. Everybody has the verdict form. I have the originals. Y'all have copies. You're welcome to use them as you see fit. Y'all ready for me to bring the jury out?
Yes, Your Honor.
Okay. Margaret, if you'll ask them if they're ready, and if they're ready, they can come on out. All right, you all maybe have a seat. Members of the jury, as you are very well aware, one of yours is missing. And so what I think I said it yesterday, but I don't have any memory of saying it, that it's a 6-person jury. And there's still 6 of you here because 6 of you were going to make the decision yesterday and one of you was an alternate. Now all the 6 of you will be making the decision and there are no alternates. And so we're not certain where Mr. Westmoreland is. We haven't had any contact with him, but we've reached out to him. So we're going to keep moving with the trial. We still have all of you that we need. But I just wanted to at least acknowledge the elephant in the room that he's not here and we're going to keep going. So we also got your lunch order and we're going to take care of that. So we're going to work through lunch and give you all food. All right. So here's where we're at. So the state called all their witnesses. I appreciate your patience as I kept us late last night. I really wanted to get us to that finishing point and it worked. And again, if that caused any of you any difficulties, I'm so sorry. That's always the push and pull I'm trying to balance in these cases. I'll start with the state this morning. Mr. Ison, do you have any other witnesses to call for the state?
I do not, Your Honor.
Okay. Any housekeeping from the defense before Mr. Ison announces that he rests?
Yes, Your Honor. At this point in time, the defense would like to tender in what will be marked as defendant's exhibit number 1. It is the disposition from the 2024 case from Brooklyn.
Oh, there's a hand. Oh, she can't hear you. Soft. That's all right. Yeah, there you go. You're just soft spoken. All right, try again.
Your Honor, I'll just start from the top. Your Honor, at this time, the defense would like to tender in what is previously marked as defense 1 into evidence. It is the disposition of the Brookhaven Municipal Court. It is a self-authenticating document.
Okay. All right. And objections from the state?
I objected due to authentication issues, but I understand.
Okay. All right. Well, we did discuss this outside the presence of the jury before this hand, and the state's already aware that the objection is noted, and I'm allowing it to be tendered into the record. All right. And what did you want to do with that?
Your Honor, if I could publish it to the jury.
All right. Hold that thought. Does the state have any other business related to this?
Yes, Your Honor, I was going to publish, tender State's Exhibit number 6, which goes along. Get to where there's a microphone. State's Exhibit number 6, which is basically the other half of defense 1. It's the accusations from Brookhaven, according to his dispositions from Brookhaven.
All right. Any objection from the defense?
No objection, Your Honor.
All right. So then I'm going to put that Defense Exhibit 1 is tendered and admitted over objection. I'm sorry. Yeah. Defense 1 is tendered and admitted over objection. States 6 is tendered and admitted with no objection. If you all will put the two of those together, hand them to Margaret, and she will hand them to the jury. This is called publication, members of the jury. What that means is each of you are going to have a minute to flip through it. Don't panic because you're going to have it with you in your final decision making. This is just what's called a publication moment. As soon as you have passed it around, just give it back to Miss Margaret, and Miss Margaret will signal to me that y'all have had the time you need with it. All right, does that cover for the defense?
Yes, Your Honor.
All right, and Mr. Eisen, what is your next announcement for the state?
Next announcement for the state, Your Honor, is the state rests.
Okay, so the state has rested members of the jury, and y'all can keep passing that around while I'm doing these steps. So the state has rested, which means the state has provided you with what they're going to provide you in their case in chief for you to make a decision on this case. The defense has an opportunity at this point, but not, I repeat, not an obligation to present evidence in the defense. I remind you that the burden the burden is on the state at all times to prove all elements of all charges to you beyond reasonable doubt, and the burden never shifts to the defense to prove anything. And if the defendant chooses to remain silent, that cannot and will not and shall not be held against them. Do you have any evidence that you wish to present for the defense?
No, Your Honor. At this time, the defense would rest.
Okay. Therefore, those charges then stand. What we're going to do at this point is we have now closed the evidence. So remember, I'm always saying you're going to make your decision off of the evidence. The evidence is closed. You have all the evidence that you're going to receive on this case. What's going to happen next is I'm going to let you all finish passing that around while they get just a minute to get their notes ready to do their closing arguments. Now, do you all, Mr. Eisen, you have the right to go first and last or both? Do you have a preference?
I would rather just go last.
Okay, so y'all take a moment, get your notes straight. So the order of events from this is going to be, in just a moment, I'm going to read to you all the law on this case, which is just as boring as it is important. You also don't need to hang on every word because you will have this document I'm holding up in the room with you for you to use in your deliberations. And so if you catch a point and you want to circle back to it, you will have this to reference. When I've read about 98% of this document, I will stop. And then Mr. White will then do his closing arguments. Then Mr. Eisen will do his closing arguments, and then you will go back in the back to begin your deliberations. And probably somewhere pretty close after that, we'll have lunch delivered and get it back there so that y'all can both eat and do your deliberations at the same time. All right, so here we go. Charge to the jury, State of Georgia versus Christopher Alexander Stringer, State Court of Spalding County, accusation 25 SR 0282, accusation filed February 19th, 2025. You are considering the State of Georgia versus Christopher Alexander Stringer. The defendant in this case has been charged through an accusation filed by the Solicitor General of Spalding County with count 1, driving under the influence of alcohol, count 3, leaving the scene of an accident, count 4, failure to maintain lane, count 5, obstruction of an officer, and count 6, obstruction of an officer. I'm now pivoting and I'll read you the accusation, and you are to interpret what I'm reading as questions for you to answer. Accusation, State of Georgia, County of Spalding. On behalf of the people of the state of Georgia, the undersigned as prosecuting attorney for the county and the state aforesaid does hereby charge and accuse Christopher Alexander Stringer with the offense of driving under the influence, for that the said accused in the county and state aforesaid on or about the 15th day of December 2024 did unlawfully drive a moving vehicle while under the influence of alcohol to the extent it was less safe for him to drive. Count 3. And I'm not going to read every word of it. I'm going to jump to the language of the charge, is that on or about December 15th, 2024, did unlawfully being the driver of a vehicle involved in an accident resulting in damage to a vehicle driven by Charles Davis did fail to stop his vehicle, immediately return to the scene of the accident, and did fail to give his name, address, registration number of the vehicle he was driving. That was count 3. Count 4, on or about December 15th, 2024, did unlawfully, while operating a motor vehicle on a public roadway, fail to drive within a single lane and move from such lane without first ascertained that such movement could be made with safety. That's count 4. Count 5, on or about the 15th day of December, 2024, did unlawfully, knowingly, and willfully obstruct Lieutenant Jacob Strock, a law enforcement officer, in the lawful discharge of his official duties by resisting a lawful arrest by said officer. Count 6, on or about the 15th day of December, 2024, did unlawfully, knowingly, and willfully obstruct Deputy Richard Carr, a law enforcement officer, in the lawful discharge of his official duties by failing to comply with lawful commands from said officer. These being contrary to the laws of the state, the good order, peace, and dignity thereof, Patrick M. Shepard, Solicitor General, Spalding County State Court. This accusation was filed with this court on February 19th of 2025. To this accusation, the defendant has entered a plea of not guilty. The accusation and the plea of not guilty form the issue which you have been selected, sworn, and impaneled to try. Presumption of innocence, burden of proof, and reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in their favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce or to prove innocence. To introduce evidence or prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, lack of evidence, or conflict in the evidence. After considering all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Evidence. Your oath requires that you decide this case based upon the evidence. Evidence is how any fact that is put into issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during trial. Evidence does not include the accusation, the plea of not guilty, opening statements, closing arguments of the attorneys, nor questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Limited purpose, other act evidence. Certain evidence has been admitted for limited purposes only, or limited purpose only. You may consider it solely for that limited purpose and for no other. In this case, the state offered evidence of other acts allegedly committed by the defendant, and you may consider such evidence, if at all, only for the issues of intent, knowledge, and absence of mistake as they relate to the counts 5 and 6 obstruction of an officer. Before you may consider any such other act evidence for that limited purpose, you must determine that it is more likely than not that the defendant committed the other acts. Second, if you make that threshold finding, you may consider the evidence only to that extent, if any, that it sheds light on intent, knowledge, and absence of mistake. Regarding the obstruction charges, you may not use it to show the defendant's propensity or character to commit crimes, and by giving you this instruction, the court expresses no opinion about whether the defendant committed any other acts or what, if anything, those acts prove. Credibility of witnesses. You, the jury, must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Impeach. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which that witness testified, or another way to talk about impeachment is that the credibility, actually that's a mistake, but that's okay. The defendant in a criminal case may take the stand and testify and would be examined and cross-examined like any other witness. If so, you would have evaluated such testimony as you would that of any other witness. However, a defendant does not have to present any evidence nor testify. And if the defendant chooses not to testify, you shall not consider that choice in any way in making your decision. Affirmative defense, mistake of fact. You may not find the defendant guilty of the crime charged if the defendant's alleged criminal act or failure to act was caused by a mistake about a fact, and that fact, if true, would have justified the defendant's act or failure to act. However, mistake of fact is not a defense to a crime if the mistake is brought about by the defendant's fault or negligence. Definition of a crime. The defendant is charged with crime against the laws of the state. The crime is a violation of the law of the state for which there is a joint operation of act and intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or may be, in your own discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law. It simply means to intend to commit the act that is prohibited by law. There is no presumption of criminal intent. No defendant will be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, or other circumstances connected with the act for which the accused is being prosecuted. Count 1, driving under the influence of alcohol. It shall be unlawful for any person while under the influence of alcohol to drive any moving vehicle anywhere in the state. The driver of a motor vehicle is under the influence of alcohol when the person is affected by alcohol to the extent it is less safe for the person to drive than it would be if the person were not affected by alcohol. A driver who is less safe is less efficient, less skillful, less coherent, less able, less qualified, and less proficient. In deciding this issue, you may consider anything in the evidence that you find relevant in deciding whether the defendant was a less safe driver. Specifically, as to the consumption of alcohol, you may consider, among other factors, the smell or lack of smell of alcoholic beverages on the defendant's breath and or person, and as to whether as to whether the defendant was less safe to drive, you may consider the factors you deem relevant, as including but not limited to the actual manner of driving the motor vehicle, the defendant's control of his mental and physical abilities, the defendant's demeanor, the physical condition of the defendant, and any expert testimony. Merely showing that the defendant had been drinking or that there was a smell of alcohol on the defendant's breath without proof of the manner of driving or the ability to drive is insufficient to prove the defendant was guilty of driving under the influence. DUI intent. To prove DUI, the state need not prove that the defendant intended to commit the offense of driving under the influence, but the state must prove that the defendant's condition of being under the influence of alcohol to the extent of impairment, and while in that condition, the intent to drive. This general intent may or may not be inferred from the conduct of the accused and other circumstances. Driving under the influence, DUI, absence of a chemical blood test. The defendant's refusal to permit a blood test shall be admissible as evidence for the sole purpose of explaining the absence at trial of a chemical test and not as evidence of the defendant's guilt. Count two. Members of the jury, there is no count two in this matter for you to consider, and you shall not speculate as to the absence of count two. Count three, leaving the scene of an accident. It is unlawful for the driver of any vehicle involved in a collision resulting in damage to a vehicle driven by any person to fail to do the following. Number one, immediately stop the vehicle at or as close as possible to the scene of the collision. Two, give their name, address, registration number of the vehicle driven. Three, upon request and if available, show their driver's license to the driver of the other vehicle. Four, render reasonable assistance to any person who may have been injured in the collision. And five, remain at the scene of the collision until fulfilling the requirements I have just set out. Four, failure to maintain lane. Whenever any roadway has been divided into two or more clearly marked lanes for traffic, a vehicle shall be driven nearly as practical within that single lane and shall not be moved from such lane until the driver has first ascertained that such movement can be made with safety. Counts 5 and 6, obstruction of an officer. Members of the jury, regarding the charges of obstruction of a law enforcement officer, the state must prove that the defendant, number one, knowingly and willfully. Two, obstructed. Three, a law enforcement officer. Four, in the lawful discharge of their official duties. The state must also prove that the defendant knew that the alleged victim was a law enforcement officer. And this may be shown by evidence that would cause a reasonable person to know that the alleged victim was, in fact, an official law enforcement officer. Venue. Members of the jury, the accusation alleges that each of the alleged offenses charged here in Spalding County. The location of the offense within Spalding County is an essential element of the offense and must be proven beyond a reasonable doubt by direct or circumstantial evidence. Statute of limitations. Members of the jury, the law in our state sets a time limit upon the state in starting prosecutions for criminal offenses. The defendant is on trial for a misdemeanor offense. Under Georgia law, the prosecution for this offense must begin within 2 years after the offense has been committed. In other words, the accusation in this case was filed with the clerk of this court on February 19th of 2025. If you find from the evidence that the accusation in this case was not filed with the clerk within 2 years after the offense was committed, it would be your duty to acquit the defendant. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. You should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, gender, sexual preference, local or remote residence, and economic status for or against either party. Additionally, more specifically, do not decide this case on implicit biases. Everyone, including me, has assumptions and feelings and perceptions and fears and stereotypes. These are called implicit biases, and we may not be aware of having these implicit biases. These hidden thoughts impact what we see and hear, how we remember what we saw and heard, and how we make important decisions. You are making very important decisions in this case, and I strongly encourage you to evaluate the evidence carefully and resist jumping to conclusions based on personal likes and dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, and biases. The law demands that you return a just verdict based solely on the evidence, not implicit biases. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and instruct that law to you. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I have given to you in this charge to the facts as you find them to be. Deliberation procedures. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. If, after considering the testimony of the evidence presented to you, together with this charge of the court, should you find and believe beyond a reasonable doubt that the defendant did commit the offense charged in a specific count on the accusation, then you would be authorized to find the defendant guilty. And on that count and in that event, the form of your verdict would be, we, the jury, find the defendant guilty as to that specific count. And when you look at the verdict form, you'll see that each count is numbered here at the bottom. And to the right, you can see that there are two options and you're to circle one. So on the left is not guilty and on the right is guilty. And that option is for each of the charges that you're to make your decision on. If you do not believe that the defendant is guilty on a specific count, and because you have reasonable doubt as to the defendant's guilt as to that specific count, then it would be your duty to acquit the defendant as to that specific count, in which event the form of your verdict would be, we, the jury, find the defendant not guilty as to that specific count. The accusation has the verdict form on the front, which has a place for you to circle as your verdict indicates. And as to each individual count, your foreperson will circle either not guilty or guilty as you unanimously find. Whatever your verdict is, it must be unanimous. That is, agreed by all. The verdict must be signed by one of your members as foreperson, dated, and returned to be published in open court. Please be certain to complete your verdict in ink. One of the first duties when you get back to the jury room will be to select one of your members to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all six of you freely and voluntarily agree. You must make fully independent and separate decisions of either not guilty or guilty for each count regarding the defendant in this trial. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of this case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. Members of the jury, by no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion on the facts of this case, the credibility of the witnesses, of the evidence, upon the guilt or innocence of the defendant. The court's sole interest is that this trial be conducted fairly in accordance with the law. All right, that's 98% of that charge, and I just had my moment to shine. So everybody shake that off. What we're going to do at this, I know, there's no getting around how boring that is, but that is one of the most essential parts of my job. So it's in the key result area of my job description. Okay, so everybody shake that off. What we're going to do now is closing arguments, which is much better than what I just did. Mr. White will go first, and then Mr. Eisen. Mr. White, the floor is yours.
And Your Honor, if I could.
Yes. Ready?
This case began with an accusation, but it does not end with an accusation. It ends with proof. Proof that you obtain from the witnesses who testified in the case and from the exhibits that were entered into the case. And that proof needs to be enough to eliminate all reasonable doubt in the case. In this case, the state has charged Mr. Stringer with 5 different counts. The judge just read them to you. But the issue with the case is that that's the easy part. Accusing somebody of a crime is simple. Actually proving every element of those offenses beyond a reasonable doubt is the hard part. And now that you've been given all the evidence in the case, you will notice that not only is there reasonable doubt, that it is numerous. The state wants you to make a number of assumptions in this case. They want you to assume that Mr. Stringer was driving and was the vehicle involved in an accident around 8:30. They then want you to assume that that same vehicle that they found 3.5 hours later must have been the vehicle that was involved in that earlier crash. They then want you to assume that these manifestations that they claim were as a result of drinking affected his driving that allegedly occurred 3.5 hours earlier. They also want you to assume that any potential resistance in an obstruction case must be willful and knowingly. And they also want you to assume that a matter that occurred 4 months before this one in a completely unrelated case informs your opinions and shows that he must have been obstructing in this case. Ladies and gentlemen, I told you something early on in the case. An officer's conclusion is not proof beyond a reasonable doubt. What I want to do is I want to go over each of the offenses, and I'm merely going to point out what evidence the state has shown, but more importantly, what evidence the state has not shown. And that informs doubt in your case. The first offense that the state charged was driving under the influence of alcohol. These are the elements of it. A person should not drive or be in actual physical control of a moving vehicle while under the influence of alcohol, to the extent that it is less safe for a person to drive. But there are issues with some of these elements. The first being while under the influence of alcohol. As you heard testimony from the officers, there are no field sobriety tests in this case. And there is an opportunity to present them. Either Deputy Carr or Lieutenant Stroke could have asked Mr. Stringer to complete field sobriety. They did not. In fact, they didn't even talk about alcohol at all with Mr. Stringer, despite claiming that his vehicle reeked of alcohol. Despite that claim, they did not feel the need to question Mr. Stringer on it. Additionally, you'll know that there's no chemical tests in this case. No blood, breath, or urine tests. Now, the state is going to bring up and talk about the fact that, well, Mr. Stringer denied the blood test. And yes, that's true. But that is his constitutional right to do so. Nor is it his duty to provide evidence against himself. It is the state's burden to provide evidence to remove reasonable doubts from your mind. As Trooper Baker testified, he could have got a warrant. Nothing prevented him from doing so other than his own actions. He decided he was not going to get a warrant because if he had got a warrant and we had got a chemical test, we would have known what was in Mr. Stringer's system. But he chose not to do that. Now, the state will then say, well, there are physical manifestations. They'll talk about the bloodshot, watery eyes. But as Trooper Baker also mentioned, he saw him after he got tased. Shockingly, being tased can result in bloodshot and watery eyes. Being tired can result in bloodshot, watery eyes. And not only that, Lieutenant Strzok and Deputy Carr gave two different answers as to his eyes. Deputy Carr said his eyes may have been a bit red. And Lieutenant Strzok said, I saw his eyes, but I also know that he was sleepy. That is not enough to show that that particular physical manifestation was a result of alcohol. But that wasn't the only physical manifestation that the officers talked about. They also mentioned some alleged slurred speech, but the officers weren't consistent with that as well. Lieutenant Strzok said his speech may have been slurred, but Deputy Carr said his speech was perfectly normal. The officers in this case cannot even agree on the physical manifestations that allegedly show that Mr. Stringer is under the influence of alcohol. That's important. You also must take into account how much time occurred between this accident and when they found Mr. Stringer. It was 3.5 hours. Even if Mr. Stringer was the person involved in the initial vehicle crash, there is no proof and no evidence that he could not have taken or ingested alcohol after driving. The state mentions during direct and redirect of the officers that there was no open containers around the car. But of course, I just simply mentioned that is 3.5 hours. That is an incredibly long amount of time. Long enough to potentially dispose of any empty containers. And I'm not trying to imply that Mr. Stringer did drink any alcohol on that day. But the issue with the case is that the timeline doesn't match up with what they need to prove. But that is not the only element of driving under the influence that is problematic. There's also an issue with this element that you must find that Mr. Stringer was less safe to drive, not because he's a bad driver, not because he was maybe sleepy at the time, not because he was distracted, purely because of the alcohol that was allegedly in his system. And the thing is, well, you don't have any proof of how he normally drives. People get into accidents without being under the influence of alcohol literally every single day. The state needs to prove, one, that of course he caused the accident, which I'll get to in a moment. But they, more importantly for this charge, they need to prove that that accident was caused, or that less safe driving was caused, because of the alcohol in his system. Normally, you would have field sobriety tests that would show how he can move, how he's walking, that can potentially inform you of how he may drive. You don't have that in this case, nor do you have any evidence of his prior driving. The state simply cannot prove that any alleged manifestations of driving earlier were done because of alcohol in Mr. Stringer's system. But of course, we also have other charges, leaving the scene of the accident. The judge just read this to you, but I really want to focus on one aspect of this. It is unlawful for the driver of any vehicle involved in a collision. In other words, they need to prove Mr. Stringer was the actual driver involved in that accident. But there's issues with that evidence. You've heard me go on and on about what color the vehicle was that Mr. Davis said he was struck by. He said it was a light blue color. Officers later said that it was blue or bright blue. But the evidence says that he only ever described it as one color.
Okay, from the racetrack headed southbound. Between Valier Road and here, a light blue car.
Yeah, cause see, when I was talking to him this morning, the victim of it, he was like, yeah, it was like this lighter blue. It wasn't like a blue.
So I figured I'd let
He said light blue.
Yeah, and then you.
Mr. Davis said the car was light blue. And you can see what Mr. Stringer's car looks like. That's not light blue. It's a dark blue at best. It's not light at all. But that was not the only evidence that was introduced. We also know that they stopped a completely different vehicle in this case. Because the description given by Mr. Davis was generic enough to apply to multiple different vehicles. The officers already made a mistake. And they need more evidence to prove that Mr. Stringer's vehicle was actually the right one. But the issue is, one, Mr. Davis couldn't tell you anything about the driver of the vehicle. Couldn't tell a face, couldn't say a tag number, couldn't tell a make, couldn't tell a model. In addition, no one witnessed Mr. Stringer driving. No one can purely say that it was him who was ever driving that vehicle or that he was driving earlier at all. But more importantly, what the officers could have done to actually confirm that the vehicle that Mr. Stringer was driving hit the vehicle Mr. Davis was driving is they could have done some forensic analysis. They could have gotten the paint off of Mr. Stringer's car that they said came from Mr. Davis's vehicle. They then could have got paint from Mr. Davis's vehicle, and they could have compared them. Not them specifically, but the Georgia Bureau of Investigations. And they could have sent it in. They did not. But they didn't want to do that. They also could have measured the damage on the vehicles. Actually make sure that the damages matched up. As opposed to just looking and assuming they did. But they didn't do that either. These things combined create reasonable doubt that Mr. Stringer was ever the driver of the vehicle. And most of these things could have been further investigated by the officers in this case, but it was not. The state also charged Mr. Stringer with failure to maintain lane due to allegedly getting out of his lane when the accident occurred. But the same issues from leaving the scene of the accident apply. They still have to prove he was the driver. And as I previously just stated, they cannot. They could have if they had done a bit more investigation, but they simply didn't. Then we get to the final two charges, obstruction. These are the elements of it. The state must prove each of them beyond a reasonable doubt. The first one, of course, is knowingly and willfully. But the thing is, as the officer stated, he was complying with them. You can see it for yourself.
Hey, buddy, what's going on?
How's it going, man?
You doing all right?
Yeah, how are you doing?
Good.
Yeah.
What you doing here?
I was just parking there.
Okay. Where are you from?
I was coming from Atlanta, going to Tequila.
Okay. You got your driver's license?
I don't have it on me.
Do you have a valid driver's license?
I do, yes, sir.
What's your name?
It's Chris.
On your driver's license, it's Chris or Christopher?
Christopher.
Last name?
Stringer.
Huh?
Stringer. STRINGER.
What's your date of birth?
6/10/91.
What happened to the front of the car?
I was driving, hit something.
Obviously.
Yeah.
Okay. Where'd you hit something?
I was driving down the street and
What street?
I don't know the streets around here.
So you're going from Atlanta to Tacoola, right? Tacoola in Gwinnett, so up near Atlanta. No, you ain't nowhere near Atlanta, right? You went the wrong direction. Okay, is this your vehicle?
It's not under my name.
Okay, who's it registered to?
Rick Anders.
Rick Anders? Who is that?
This is my girlfriend's dad.
Okay.
Yeah, so she's in his car to get to work.
He let you borrow it to get to work? Where's your girlfriend?
She's at home.
Okay. Alright, well just hang tight here with my partner, alright?
You'll notice Lieutenant Strong asked Mr. Stringer a number of questions during their interaction, and he answered every single one. He may not have given Lieutenant Strong an answer that he wanted, but he answered them. He was complying. And when Deputy Carr came up, the same thing occurred.
Hang tight here with my partner, alright?
Hey, LT. This matches the hit and run, not the Avenger. This matches damage from the hit and run and what the driver said.
Which one?
The one that I worked on the expressway this morning.
Oh, well, talk to him.
Hey, bud. What's up, man? So where you coming from? I wasn't here when you explained to him, so where you coming from?
Yeah, I mean, I just talked to him about it, so.
Well, that's why I'm asking.
Okay. Yeah, I mean, I'm coming from Atlanta.
You coming from Atlanta?
Yeah.
Okay. Were you on 1941 this morning?
I did 41.
That's the one that comes from Jonesboro and all that stuff down here.
I'm not sure. Like, I had my phone, but I don't have it with me right now, so I was trying to navigate my way back, but I just did my best, but I went the wrong way, so.
Okay. Where'd you take the wrong turn at? I'm just trying to figure out where you might have gotten lost at. That's all I'm trying to do.
Yeah, I mean, I wouldn't be able to tell you. I did my best to get back, but I don't know. I wish I could tell you. So.
How'd you end up right here? Because, I mean, you kind of got to drive over some sketchy stuff to get back here.
I made a wrong turn, realized I didn't know where I was, so I pulled over here. So.
Okay. Did you not have a wallet or anything with you?
No. Well, it's probably in the back somewhere, but.
What do you mean in the back? Like in the back seat or in the trunk?
Trunk.
In the trunk? Okay. So you don't know what you hit?
Similar to with Lieutenant Strzok, Deputy Carr asked questions. Mr. Stringer answered them. He's complying. He's listening to them, and he's following what they're asking him to do. But then, he was also not belligerent. He wasn't yelling, and he wasn't trying to cause harm. Not only did you get to see proof of that, the officers confirmed it on the stand. At this point, all that's happened is he's been approached by officers, they've asked him questions, and he has complied with them. Seemingly no issue. But then Lieutenant Strzok comes up to the car, asks him to get out, which he says, yeah, I will. He goes to move towards the door, and he gets grabbed, which is confusing and shocking. Because up to this point, he's been doing everything he's supposed to do. Officers approached him. They asked him questions. He answered. The officers made mention of the fact that he did not answer the questions in a way that they liked. But we've all had conversations. Sometimes you don't get the answer you want. But he's just simply needed to give them a response and answer their questions to the best visibility. He did that. And Despite that, they gave him probably about 1, maybe 2 seconds to comply before grabbing him. Lieutenant Strzok said that, well, I intended to arrest him at that point. But he made no mention of that. He escalated the situation beyond what it ever had to be. Because like I said, Mr. Stringer was complying. Georgia courts have ruled that merely not immediately following a officer's command, that is not enough to be obstruction. That's what happened in this case. He didn't immediately do what they asked. Not that they gave him enough time to do so. And what resulted was this.
Well, do me another favor and step out of the car for me. Step out.
I'm
Step
trying.
out.
I'm trying. Why are you trying?
You're gonna get tased if you don't get
I'm,
out.
I'm doing my best to get out of the car.
Get out of the car. You're gonna get
I
tased.
will. Why are you guys pulling me? I'm trying to.
Get out.
Look, I'm trying to
Get
out of the
out
car.
now,
I
or you will
am.
be tased.
I'm trying.
Get out.
Why am I getting pulled?
Get out.
I'm trying to.
You're about to be tased. Get out of the car now.
I'm trying to.
Get out of the car.
Why are you guys pulling?
It's confusing why a person who is fully complying with officers is all of a sudden grabbed by them and being yelled at. It's shocking, given that he did everything that they had asked by that point, but now he's being manhandled. The state wants to argue that Mr. Stringer was doing this intentionally, that he was doing this willfully and knowingly. But the truth is, he was confused. That's why he's asking questions. He's wondering, why are you pulling me? Because before that, he was complying. He's wondering why they're yelling at him, when seemingly the conversation was going normal. The state made a number of mentions during direct and cross-examination that Mr. Stringer seemed to be moving toward the other door. And they want to say that, look, that's proof that he's trying to obstruct them. I would say that's proof that he's trying to figure out why they're doing this to him, and his body is tensing up as a natural reaction. Because that's what we do when we're confused, we're shocked, and we're afraid. As I mentioned earlier, the officers in this case could have handled this situation differently. He was complying. He wasn't a threat. And they could have just simply said, hey, get out the car, gave him ample time to do so, maybe do those field sobriety tests we talked about earlier. Then they could have arrested him. But they decided, I gave him about maybe 1 or 2 seconds to comply, and he didn't in that time. So I'm going to put my hands on him, and I'm going to force him out. And of course, the state also wanted to introduce a similar incident that occurred about 4 months prior. The state wants to introduce that to show that, look, Mr. Stringer had knowledge of what happens when you don't listen to the police, and that because of that, his alleged obstruction was not a mistake. It was intentional. But the issue is, well, there's a number of issues. First being, well, those are 2 separate incidents. That one occurred earlier. If anything, it shows that Mr. Stringer learned from the earlier incident. You saw the video of the earlier incident. You saw that he wasn't necessarily trying to comply with officers during that event. But this time is different. He's answering all their questions. He's learning. The last time he had defied officers, he got tased. And I've never been tased before, but I hear it's not fun. He doesn't want that to happen again. So now he's doing everything he can do to avoid that situation. But the most important thing about the 2024 obstruction is that, as you all got to see, it was what we call null pros. Or, in layman's terms, it was dismissed Now, I expect the state to get up here and argue that, well, it was dismissed as part of plea negotiations. And it may have been. There's no one to testify of why it was dismissed. But I do know it was. For whatever reason it was. That is the fact of the case. The truth in this case is that there are a number of holes in it. There are a number of assumptions, and then there's no follow-up on those assumptions. They stop at step one. They make an accusation, and then they decide guilt. But there's a step in between. Some investigation, a bit more prodding, a bit more looking into the situation. They had numerous times to do that for all the charges. For the DUI, they could have tried to obtain field sobriety. They could have tried to obtain a blood test. They could have tried to look further into the damage to the vehicle to make sure it matched so that they didn't make another mistake like they made earlier. They could have compared the paint swatches. None of this was done. And because of that, it only really leads to one conclusion in this case. Not guilty. Thank you.
All right. Mr. Jackson?
Excuse me.
Good morning, ladies and gentlemen. I believe it's still morning. Yes. Let me begin by saying thank you for your service in this case. I believe I speak for everyone here when I say that your service is a necessity and the criminal justice system couldn't function without you. And I know you got to stay a little late yesterday, but I appreciate your service. That's part of it. Now, ladies and gentlemen, at the beginning of this case, I told you what I expected the evidence to show you. And I believe that everything I told you in my opening statement has come to pass. But before I go over the testimony given in this case and what it means, I would like to take a moment just to discuss reasonable doubt with you, which the judge has already told you about. It is not proof to a mathematical certainty. That would be basically impossible unless you were there or it happened or whatever it was that we're discussing happened to you. It's a doubt to which you can assign a reason. It's like if you have a 100-piece puzzle and you put it all together, and maybe there's a piece not here or there, you still know what the picture is. It's reasonable for you to understand that. But what I would like to do at this point is start with Charles Davis. If you remember him, he's the second witness I put up there. He was a guy driving down the road, minding his own business, when out of nowhere from behind him, a blue passenger vehicle swerved over into his lane, smashed his driver's side rear wheel and wheel well. A car he ultimately, from the stand, described as a bright blue, said in the thing light blue. Ladies and gentlemen of the jury, I submit to you, the car was blue. It depends on what somebody's going to say. You can say blue and think it's light blue or a dark blue somewhere. It was a blue car that hit him. He was driving down the road when he got hit. He got disabled, had to drive off the road while the other car didn't slow down and kept going. Of course, he doesn't have the tag. Of course, he didn't see who was driving. Of course, he doesn't know the make and model. But he does know that a blue car hit him. Excuse me. And he was hit from behind with a car that he never saw coming, and he had to leave the roadway. There are a couple things that we know for sure from Mr. Davis's testimony, and that is that he did not leave his lane of travel as he was hit in his own lane, that he was hit at the driver's side rear wheel well by a blue passenger vehicle that swerved over into his lane and struck his Ford F-150 with the passenger side of the car at around 8 a.m., sometime between 8 a.m. and 8:30 a.m. on Highway 1941. We know that there were no traffic control devices directing anyone to merge into the right lane or saying there's only one lane of travel. We know that the blue passenger vehicle did not have a blinker on or attempt to turn. Only that Mr. Davis saw the blue passenger vehicle keep on trucking down the road. We also know from his testimony when the defense asked him, the an insurance company had paid for his car, his truck. And when pressed by the defense, whose insurance company, Mr. Davis stated it was the insurance company that insured car that the defendant was driving. So the insurance from that car, that blue passenger vehicle, paid for Mr. Davis's car. Now let's talk about Trooper Baker. He's the one that responded to the side of the hit and run and checked on Mr. Davis and his vehicle. We also know that after listening to his testimony and watching on video, that he did go to the scene where Lieutenant Strzok and Deputy Sheriff Carr had arrested earlier arrested the defendant. That is where he read the defendant his Miranda rights, where the defendant stated he did not want to talk to him. And then Trooper Baker read the defendant the Georgia implied consent warning, which he also read out loud here in court, where he asked the defendant if he wanted to take a blood test, and the defendant again said no. We also saw Trooper Baker on the video go down to the defendant's car and report that he saw red fiberglass transfer on the defendant's vehicle that was severely damaged. And on the, as I call it, the chunk in the trunk, the defendant at some point had to have placed in his trunk at some point during the day, which was also found and seen by both Lieutenant Strzok and Deputy Sheriff Carr. Next, we have the testimony from Lieutenant Strzok and his video. All of you heard and saw what happened there. Lieutenant Strzok saw a blue passenger vehicle sitting in an abandoned lot by an abandoned building on a lot that was partially hidden from view by trees and was littered with all kinds of trash. As you saw in the video, Lieutenant Strzok said when he originally passed by, he saw someone sitting up in the driver's seat as he passed by. And then as you all saw on video, which is being filmed, right as all this was playing out, not almost 2 years later here, when he came back, that the defendant had laid down in the driver's seat. All of you saw the defendant's demeanor when he was answering questions from Lieutenant Strzok. He couldn't, he gave an answer, but, where were you going? To Decula? Decula is, I would just go on record to say, approximately 80 miles away in Gwinnett County, and he's coming from Atlanta. He drove, 40 some odd miles due south instead of due east to Griffin. You compare that with also what he told Deputy Sheriff Carr. He had his phone, but he didn't, and he did his best. There are road signs all the way from Atlanta to Griffin. He did not state that he had any family, friends, or contacts anywhere in Spalding County. I would submit to you, the jury, that driving from Atlanta, trying to get to Decula, and driving all the way to Griffin, it's kind of a big mistake to make. That's more than a wrong turn. That's a journey. But he couldn't tell that, couldn't tell you the name of the streets. Shows you he's unaware of this town, this county. Excuse me. And then again, trying to make the point that the defendant was polite and complying. That's notable because, again, he never gave a reason why he was here other than he got lost. Well, that's a big way to get lost. He has damage to his car, severe damage to his car, not a dent, not a flat tire. As you saw in the video, the front quarter panel's ripped off. And that trunk, again, was thrown in, at some point, was thrown in the trunk. What we also know, based on Mr. Baker's testimony, is that as he's driving down the road, get this out of the way, I'm sorry, ladies and gentlemen. As he's driving down the road, he gets hit in the rear behind him on the wheel well, in the wheel. He testified he didn't leave his lane, which means the car that hit him had to leave its lane. And I would argue to you that it is consistent that the damage on the blue passenger vehicle that the defendant was driving, the damage on it is consistent of where it would have hit the truck. came in, sideswiped him, kept going. It wasn't damage on this side of the car. What damage behind the car? It was right where it would have hit him. And the car kept on going. But it appears the car was found in a lot. By the way, also in answering questions, we want to stop to take a break, this, that, or the other. You saw where that car was stopped. That's a place you have to look for. Why couldn't he stop it? Parked in the parking lot at Walmart or McDonald's or Kroger or somewhere. For somebody who doesn't explain on video that they're actually says not familiar, doesn't know the streets, not familiar with Griffin and Spalding County. How did they end up there? That's something else we don't have answered. And then you saw the trooper, you saw Lieutenant Strzok, you saw a deputy sheriff go down there, look at the car, say there was red fiberglass transfer, which would be something that would match Mr. Davis's truck per his testimony on it. So at all this, we have a blue passenger car that was involved in a wreck, and later a blue passenger vehicle that had also had severe damage. Something happened to it, parked in an abandoned lot by an abandoned building, driven by the defendant, who said he was leaving Atlanta, going to Decula, and somehow ended up in Griffin. Now, I submit to you, the jury, that that's an extremely improbable story. And then what we get to is the obstruction. When Lieutenant Strzok was on the stand, I asked him, if you remember, if he knew what was in that car. And he got very serious. He said, no, that's the unknown force. He don't know what's in that car. He has no idea. There could be weapons. There could be a knife, gun, any kind of weapon that could be used to harm him. I also asked him that once you run somebody through GCIC and find out they have a suspended license or an outstanding warrant on a totally unrelated matter, what do you do? Well, we arrest them. So when he went back down to that car, he was going to arrest the defendant. That's why I asked him to step out. When I asked him to step out, he said okay, but he didn't step out. So he reaches in, he grabs him. At that point, we see defendant saying, I'm trying, while at the same time pulling backwards. Pushing backwards to the point where those two officers, Lieutenant Strzok and Deputy Sheriff Carr, could not remove him from the vehicle. Two grown men could not remove one grown man from the car. Although he's saying he's trying to get out. Now, to show knowledge and intent and absence of mistake, we have the incident from Brookhaven. Put your hands behind your back. They got one hand. Put your hands behind your back. He wouldn't do it. They finally had to tase him. This instance, get out of the car. And they said resisting arrest. And he goes, I'm not resisting arrest. And then he gets tased. So then we get to this case, which, by the way, the Brookhaven incident was about 4 months prior in August, just short of 4 months. And then on this, the defense counsel showed you, the obstruction was null prost, and he pled nolo to disorderly conduct. You got State's Exhibit 6 here showing that from that Brookhaven incident, he was charged with disorderly conduct and obstruction and interference. And defense counsel rightfully told you that I was going to get up here and argue plea negotiations. I am, because that's what we do. That's what my office does on a daily basis. Hey, you got these two charges. If you'll plead to this, I'll get rid of that. It also shows that the sentence he got, $500 fine and 2 days in jail for the disorderly. And I would also point out, in looking at this, the disorderly, where is it? I'm trying to, pardon me for a second. Yes, that he pled to the disorderly
which I'm stating my own opinion on that, but he was guilty of in the video. But the same thing happened. That's why it's there, to show intent. He intended not to get out. He intended to obstruct and knowingly and willfully do it. You heard all the evidence about, I asked them repeatedly, were you in a uniform? Did you have your badge on? Were you in a law enforcement vehicle? He knows they're law enforcement officers. I asked them if it was their lawful duty to arrest them. Yes. Were you hindered? Yes. He would not get out of the car, so he had to be tased. Now, I would also tell you, yes, it was 4 months prior. That seems like a long time ago, which I don't believe, but a long time ago. But on his court date, where he came and entered his NOLO, was on November 14th. Basically a month, December 15th is when this happened, basically a month before. So he didn't get out of the car and had to be tased again. I would argue that he wasn't learning, that he hadn't learned. I would also argue that, as defense counsel said, no, I asked, were there any open containers in the car? Were they around the car? Were they in the car? And no. So to say that he had been drinking in the 3.5 hours after that, where's the evidence of that? There is none. Now, they did tell you he smelled of alcohol. They even told him Carr to roll his windows down. And y'all saw his demeanor. Y'all saw when Strzok first talked to him. You just saw it again from the defense counsel. You know that he was driving a blue car that was damaged. You know that up the road on 1941, there was a truck that was damaged by a blue passenger vehicle. Yes, they were looking at another one. Turned out that wasn't the right one. I submit to you, the jury, when they found the defendant in his car, they did find the right one. Now, why did it escalate so quickly? Why tase? Well, you come upon a car in an abandoned lot. You talk to a person who might be answering your questions, but it's not really giving you answers. Telling you, I was going to Tequila, somehow I'm here. I hit something that totally ripped off the front of my car, but I don't know what I hit, and I don't know where I hit it. He goes back, he confirms, runs him and finds a suspended license and an unrelated warrant. Didn't know what was in his car. Car had damage consistent with a hit and run from that morning. And he didn't obey law enforcement when they told him to get out of the car. That's what ended with the taser, ladies and gentlemen. He knowingly and willfully obstructed or hindered a law enforcement officer from completing his lawful duties. So, ladies and gentlemen, I think I've made my point. You heard the testimony, you saw the videos. The defendant stated he left Atlanta to go to Tequila and ended up in Griffin. And based on what he said, because he didn't have his phone with him, I don't quite understand that. But my question to each of you is, if anything I just said, which is what the defendant said to law enforcement, is reasonable. Is it reasonable to go to Tequila and end up in Griffin? Is it reasonable to have that much damage to your car and not know what you hit or what happened? You had time to stop and put the chunk of the car in the trunk, but you don't know what you hit. Couldn't investigate that. Is it reasonable to have personal knowledge that you will be tased if you resist arrest and resist arrest anyway, only 4 months later? Ladies and gentlemen of the jury, you know what you heard and saw in this courtroom regarding this case. And I ask you to return a verdict of guilty on all remaining counts. Thank you.
Thank you, Mr. Tyson. Members of the jury, these are my final instructions to you, which is that your verdict must be unanimous. One of your first duties in the jury room will be to select one of you to act as foreperson who will preside over your deliberations and who will sign the verdict form. Again, you should start your deliberations with an open mind. Consider all the evidence carefully. In the case, deliberate with an aim towards reaching a unanimous decision, consistent with your consciences and oaths as jurors. Avoid premature fixed opinions. Consider one another's views. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should never surrender honest convictions or opinions to be congenial or in order to reach a verdict solely because of the opinions of the other jurors. You're about to go into the jury room, but here are my final items of housekeeping. During your deliberations, you must shut off all electronic devices and leave them in the care of the bailiffs until you complete your deliberations. You must not communicate with, receive any information from, or provide any information to anyone by any means about this case. Again, you may not use electronic devices at all until after I've accepted your verdict. I've got a section on alternate jurors, but we've already addressed that, so I'm going to skip past that one. During your deliberations, there will always be a bailiff outside your door of the jury room. If you have any questions for the court, write out that question, have your foreperson sign it, knock on the door, the bailiff will respond. Fold the papers with your question on it for privacy and hand the written question to the bailiff and resume your deliberations. The bailiff will bring the question to me while you continue your deliberations. Once I have an answer to your question, I will respond in writing, and that paper will be delivered back by the bailiff back to you, or I will call you out into the courtroom to address your question. Once you have a verdict, you will follow essentially the same procedure as the questions, except that as your foreperson, you will instead keep the signed and dated verdict form to bring with you into the courtroom. I will need to ask your foreperson a couple of questions about it in open court. When you return with your verdict, I will ask the foreperson to sit closest to the bailiff. All right, there's one thing missing on here, but it's not that big a deal, which is that I will personally read your verdict out in open court. You do not have to read your own verdict. So before you all begin your deliberations, please take a moment and shut your phones down. You can set them up on the banister or put them in a box. Just follow Margaret's instructions on that. Sorry to be draconian about that, but cell phones are the bane of the court's existence at this moment. They have caused all kinds of troubles because folks just instinctively want to reach to their phones to look stuff up, and we have to just physically remove that temptation. Lastly, you already figured this out, but I've been responsible for our schedule up until this moment, and effective immediately, you are responsible for our schedule. And I got a whole thing here about ordering pizza, but you've already done that, so I'm going to skip that whole section. All right. Do not begin your deliberations until you've followed these initial housekeeping instructions and the bailiffs have delivered to you the exhibits, the verdict form, and these instructions. One last off-script instruction. The videos obviously are digital and in here, but you have the right to view them if you wish. So the way this works is it's a very particular way we have to do it. If you want to watch any piece of any of the video, your foreperson writes down, we would like to watch X, Y, and Z of X, Y, and Z video. And then what we'll do is we'll all set up in here. You will come back out. I will play that part, and then you will go back out into the jury room because we don't have the ability for you to view them back there. So I'm just letting you know that you cannot watch the videos back there, and there's several, but I want to make certain you had firmly in your head that if you had a piece where you wanted to watch just from X to Y, or you want to watch the whole thing or all of them again, you're in charge now, and we're going to do exactly what you ask us to do. And I just wanted you to know what that looked like. All right, so y'all grab your phones, take a moment, shut them off. Food should be here soon. And once you've left your phones up there and you have everything else, you may begin your deliberations. James, here's the verdict form and the charges.
Mr. White, you might want to, staple.
Yeah, let's do that.
Thank you, sir.
You're very welcome.
Just as long as you don't look at these. Before.
All right, so good with James. And y'all inventory what's going out. Ms. Jackson, we're not looking. If you just kind of inventory the exhibits, make certain that what's about to go out is proper. Thumbs up.
It's for me.
Okay, any objections to my charges or any housekeeping from the state?
Nothing on the state, Your Honor.
Any objections to my charges or any housekeeping from the defense?
No, Your Honor.
Okay. All right. Well, then, I'm just going to say it's been a pleasure having you all in here. I spend so much time, trying to figure out what's going to be broken and what do I need to fix? And y'all both did a great job for your sides. And I just want to make certain you hear me say that. So,
Thank you, Your Honor.
Mr. White, we haven't had a lot of cases together, but I have to admit, I was very pleased having you down here and I hope you'll take more cases with us. So, all right. Well, then I'm going to put us off record. Food should be here any minute. And other than that, we're just waiting for the jury to knock with a question or a verdict. All right, we're off record. Okay, it is 12:27. Where we're at is the jury's now been out for a bit. We fed them pizza so they could work through lunch. We had food here so that nobody disappeared, so that if this moment happened, we would all be here ready to jump and run. So that worked. All right, here's the question. So the question from the jurors, and I've made a copy and y'all each have it. Is that correct, Mr. Ison?
That's correct.
Ms. White?
That's correct.
The question is, could we see the flock video of that Officer Stark spoke of regarding the vehicle in Hampton, Georgia without damage, 8:05? And then sign this. Well, we know who our foreperson is now. Our foreperson is Miss DeVoe. So juror 32. So here's my memory of this. Because obviously I watched the video, Deputy Carr's body camera video, and just said out loud, y'all didn't put into evidence the flock pictures. But I remember from Deputy Carr's video that the flock pictures are on that video, but I don't know what the date stamp is or whatnot. My working plan, and this is a discussion, not a statement, is the state needs to pull up Carr's body camera, go to that section, and hit pause. We would then bring the jury out. We, not at this moment, but then we'd all sit quietly, bring the jury out, sit tight. I would read the question into the record. I would direct you to play it. And then once we get past the flock moment, you would pause it, and I'd direct you to pause it. And then I would ask the jury to step back up. That's the way we've done this in the past. So think about that for a minute. Both of you kind of chew on that and see if either of you have any objections to that being the court's response. Because obviously just writing something in this situation, it isn't going to work. So, all right, Mr. Ison, have you had enough time to think about it?
Yeah, it'd take me a minute or two easily to find it. But I will look.
So again, I just remember it's on there and it's several moments in, and Ms. Sexton could probably help you find it. All right, Mr. White, your thoughts on that? Suggestions, concerns, objections, redirections?
Your Honor, I don't have any issue with that. The video was played, and I do remember it was played up to that point. So simply just showing them that is the only footage of the flock video that has been introduced into evidence, I have no objection to it.
Okay, well then let's go off record. Give the state, I'm gonna try to find my copy of the video. I don't have it quite handy. We'll find the date stamp, play it, and we're done from there. All right, we're off record, Kathy. Ready to go back on record, Kathy? All right, so let's go back on record. Mr. Ison thinks he's found it. I'm going to push it up to the screen so we can all see it. All right, it looks like time in on the video is 31:15 minutes into the video.
13, sorry, Your Honor. 12/31/13.
Yeah, so the date stamp's 12/31/13. We'll do it that way. Okay, so we'll all agree that we're going to use the time stamp on the screen facing. All right, if you'll hit play and let's see if this is it.
Excuse me. think it's actually gonna start right now at 30.
Yeah.
Fingertip there. Yep. So here's the car.
Yep.
Mirrors intact, no damage.
And see,
Failing to maintain on already.
when I pulled that picture up, it was one of those. It was too dark to really see the color of it for the guy to be able to identify it. But he told me it was a small blue car, and that was about as much as he could really give because he was more in shock about what happened.
234 dispatch. And I think it ends 15.
All right, so the ending date stamp on the screen is 12/32/15.
We can watch a few more seconds to make sure, but I
Yeah.
believe that's.
Let's do that.
I believe 15 is.
18-8, code 9, 223, and all is reportable.
Yeah.
Is somebody going right with the trooper?
Yeah.
Man said he was, but
Okay. All right, does anyone remember any other moments in that video? Because I do not remember any other moments in that video.
There's actual footage, I do not.
That's correct. That's all I remember as well. Is that correct, Mr. White?
That's what I.
Again, we're all going from our memory of what that video is. Okay, well, then, Mr. Eisen, if you'll back it up so that the date stamp on the screen is 12/31.
Is generally when it starts.
12/31/30. All right, so we're all in agreement. We've got it keyed up to, well, I'm saying we're all in agreement. You can agree in just a second or not. We're at 12/31/30 for a start. It goes to 12/32/15 for an end. I will have Margaret bring the jury out in just a second. We'll put them in the box, put the lights off. I will say, Mr. Eisen, start the video, and then you'll know to stop it at 12/32/15. I'll then officially say, Mr. Eisen has stopped the video. Members of the jury, you may return and resume your deliberations. Any objections to that process?
None from the state.
Any objections to that process?
No, Your Honor.
Anything else? Oh, yes, thank you. All right, so I'm officially entering in the question as Court's Exhibit 1. So if you all would like to mark your copies is officially and formally being tendered into the record as Court's Exhibit 1. All right, thank you, Kathy. Oh, yeah, what video is this?
Let me, I've got to get them.
Great point,
Over
Kathy.
here, over here.
Yes, S5 is what I have.
Yes. Oh,
It's cars if it says 5. That was.
Yeah, this is definitely Carr's video.
yes, that's what I have.
Okay, everybody ready? Okay, if everybody will stand up. Margaret, if you'll bring the jury out. Just tell them they won't be out long. All right, you all may be seated. Members of the jury, you have sent out the following question for me, which is, could we see the flock video that Officer Stark spoke of regarding the vehicle in Hampton, Georgia, without damage, 8:05 a.m., signed your foreperson, Mr. Vo. I have spoken about that question with the attorneys, and we have agreed that the following little sequence of the video that you're about to watch is what is responsive to that question. I'm obligated to also point out to you that just because you're seeing this little piece of the video in response to your question, you are not to give it any additional weight or special weight just because you're seeing this piece again and not the entirety of all of the exhibits. It's my obligation to say that to you. And if we view any other pieces, I will say those exact instructions to you at each time because that is my responsibility. If you will flip off the lights, we have it queued up to 12 minutes, 31 seconds, and 30 seconds. And we will, 31 minutes and 30 seconds, it will play forward through 12, this is the date stamp. So it's actually 12:31:30, and it will play through 12:32:15. Mr. Ison, you may hit play.
Hey, what's up there? Yep. So here's the car.
Yep.
Mirrors intact, no damage.
And see,
Failing to maintain almost, looks like already.
and see, when I pulled that picture up, it was one of those. It was too dark to really see the color of it for the guy to be able to identify it. But he told me it was a small blue car, and that was about as much as he could really give because he was more in shock about what happened.
234 dispatch.
All right. If you'll flip the lights back on. All right, members of the jury, that concludes the court's response to the question. So if at this time you will please return to the jury room with your deliberations, and if you have any other questions, please send them out. Oh, I'm so sorry. I was supposed to ask if anyone would like to see it again. I'm sorry, that's my fault.
Yeah.
Okay, you have that right, and I'm supposed to offer it to you. All right, they're saying no. They're good. Sorry, y'all. All right, jury's out. Any additional housekeeping from the state?
The only thing I would say is this comes another question or an issue. I don't know how to go about this. It's just off the top of my head right now. The actual flock camera footage, my understanding, was erased and it was unavailable to us in the first place. That's why.
So if it comes back up, I mean, that's the thing is, that's not part, okay, I understand your point. If it comes back up, I would say the evidence you have is the evidence you have. I would say that in a more appropriate setting, but that is normally what I would send out, is I normally wouldn't bring them out at all. I'd normally just send out a thing that says the evidence that's been tendered into evidence is what you have to make your decision. And I have language that I use for that.
And that's kind of what I was getting.
Yeah,
Just
so
there's nothing else.
yeah, that'll work. So we'll just hold on to that one in our back pocket. If they send out a question that's outside of what we can remember is on the videos, then that will be essentially my response. All right, Mr. White, any access to the record on any issues?
No, Your Honor.
All right, well, then we're going to go back off record until there's another question or a verdict. All right, everybody's at ease. Ms. Margaret, I understand that there's a verdict.
Yes.
Okay. All right, so let's talk through everybody what's about to happen. So, what's about to happen is we're gonna bring the jury out. When I bring the jury out, I'm gonna ask the foreperson, who is, Juror DeVoe, if they have a verdict, if it's unanimous, has it been, has she as the foreperson, written it down in ink, not pencil? And if she says yes, yes, and yes, then I'll have her give the verdict form to Margaret. Margaret will bring it up to me. I will review it up here. I will determine that it's in proper form. As soon as I determine it's in proper form, I will read it. Now, when I read it, this moment often has high emotions, both from the tables and from the gallery. I just need everybody to know that there are very few things in this world that I have absolutely no tolerance for. And one is disruptions during verdicts. So if you do not believe you can handle whatever is going to come out the door one way or the other, then go ahead and step out of the courtroom. We'll fill you in later as to what happened. But I don't want any outbursts of joy or despair or anything. Put your poker face on. Once I have read the verdict, I will ask you all to come up and take a look at it. And then I'll ask you if you consent to its form. And then at that point, if you want the jury polled or anything else, that's your moment to tell me. Because as soon as I get past that moment, I'm going to pivot towards releasing them from their oath. If you all want to talk to them when it's over, I will tell them they're welcome to stick around, that you all will have a few minutes to talk to them before they leave. And that, of course, if it's not guilty across the board, then we'll all be gone. If there's any guilty charges that are found in it, then once they've gone and y'all have had a chance to talk, then we'll reconvene and do sentencing. And I'll tell them that they can sit in the gallery and watch if they want, or they're welcome to go. All right. Any questions, Mr. Ison?
No, Your Honor.
Any questions?
No, Your Honor.
All right. If the jury is ready, they may come out. You all may be seated. All right, Ms. DeVoe, I assume from the questions you asked earlier that you are the foreperson. Is that correct?
That's what they say.
That you're the foreperson?
But
But you're it and you're here. So, all right, if you'll stand up for me, and I just have a couple of basic questions for you, nothing too scary, but I've just got to put it on the record.
okay,
So
these are my backup singers.
that's exactly right. And whether you like it or not, you're the foreperson, correct? All right. And have you all reached a verdict? Yes or no?
Yes.
And is it unanimous, agreed to by all of you?
Yes.
Okay. And have you written the verdict on the paper in ink, not pencil?
Yes.
Okay. And I just thought you all should know, you can see Mr. Westmoreland is here and is okay. So I just thought you all, since one of your members is here, I just realized that y'all might want to know that he's here and he's good.
That's fine.
All right. If you will please pass all of your paperwork over to Miss Margaret, she'll bring it up to me and I'll take a look at it. Thank you. This can go on. This goes to Erica, and these go back to Kathy so that goes to Kathy. Just for now, we'll sort those out in a minute. Y'all don't go anywhere until we've talked about the exhibits. Just say that out loud. Okay, the verdict is in proper form. It reads, we, the jury, find the defendant, circle one, as to count one, guilty. As to count three, guilty. As to count four, guilty. As to count five, guilty. And as to count six, guilty. All right, y'all come take a look at it. All right. Any objection to the form of the verdict, Mr. Ison?
No, Your Honor.
Mr. White, to the form of the verdict?
No, Your
All right. Any other housekeeping with the jury from y'all's perspective before I pivot to my next steps?
No, Your Honor.
No, Your Honor.
Okay, all right. Therefore, that concludes y'all's business with the court. So a couple of last thoughts and instructions. So number one, now that you have issued your verdict, I've accepted it. We've confirmed it's all appropriate. That's the last official act we need from you all. So that's the last case for the week. And so in just a moment, when I release you all, you'll be free to go all together. So obviously, since yesterday morning, I've been telling you, don't talk about it. Don't tell anybody. Don't say anything to anybody. That oath of silence is officially lifted, which means you can talk to anyone, everyone, or no one as you see fit, not as I direct. And so what that means for you all is in just a minute, I'm going to cut you loose. And when I cut you loose and you walk out of that jury box, you're officially free. And the attorneys often would like to speak to you all to get your impressions and thoughts about the case that you can, that help them understand it better, understand it from your perspective better. Now, do you have to talk to them? Absolutely not. Would they like to talk to you? Probably. So if you want to talk to them, I'll just say, hang out here in the courtroom for a minute. We'll go off record, let them talk to you. But if you don't want to talk to them, you just keep walking and you'll go right on out of the courtroom and you'll be free to go. The badges that you all are wearing, this is really silly, but y'all can keep those as a frankly very undervalued memento of your time here with us. We always give those out just so that you have, I don't know, a little something that says thanks. There's only one rule with those, which is do not wear it back to the courthouse. That will cause a lot of confusion with a lot of folks. So you may keep it, stick it in the drawer, throw it away. You're not going to hurt our feelings either way, but we want to at least give you that. Now, several of you took notes during the trial. If you did take notes, make certain that you put your notepad face down on the jury table when you go back there. The bailiffs will gather up your notes. They'll go straight into the shred bin and no one will ever see them. If you need anything as far as from the clerk's office with a note or something for your employer, you can go to the clerk's office, which is around the corner, and go from there. Now, with all of that said, do any of you all have any questions that you would like me to answer before we part ways? Okay. All right, no response. So if you will step back, make sure your notes are there. Again, we're going to go off record for a minute before we pivot to the next phase. If you want to stay for the next phase, which is the sentencing, you are welcome to do so. You would sit out in the gallery as a member of the viewing public. So if you want to stay, you're welcome to. You don't have to, and I don't have a preference one way or the other. Okay? All right, you all are good to go. So if you'll go gather up your things, put your notes face down, and we're going to go off record, Kathy, and the attorneys speak first, and when they're finished visiting, then we will reconvene for sentencing. Ready? Okay. Any housekeeping, Mr. Ison, from the state before we pivot to sentencing?
Oh, Your Honor.
All right. Any housekeeping from the defense before we pivot to sentencing?
No, Your Honor.
Did y'all have enough time to try to talk to the jurors?
I do.
Okay. Okay. Just want to make certain that y'all didn't feel rushed on that. So that was, when I was in the well, that was one of my key moments I always wanted to do is go, what do you think? What were your thoughts? So, okay. I would like to hear from the state on sentencing, and then I'll hear from the defense, and then I will give you my decision. So, Mr. Ison, the floor is yours.
At this point, Your Honor, I've turned it over to Ms. Sexton.
Okay, Ms. Sexton, I'd love to hear from you.
So, Your Honor, as you know, we have had a long history with this case. And my recommendation, of course, for the DUI is that we comply with all state regulations regarding the sentencing of the DUI. And I'm sure Your Honor is aware of those recommendations, but if you want, I can delineate them for you.
No, I'm good.
The other thing that is of particular interest to the state, which the state has not previously brought up because it wasn't pertinent to the trial, but as part of the bond revocation modification hearing, the defendant was charged with giving us a list of all of his pending litigation. And the state knows pretty much for a fact that that was not a complete list. And so that sort of got under the state's nerves about that because we were at a disadvantage because the court ordered it within 10 days of being released with anticipation of he was going to be released. And the state would have enough time to look into that. And we didn't because he didn't make bond and he wasn't released. And then we didn't have 10 days. And even when we got the list, it was not complete. And I feel like that was no longer a concern of the defense counsel because I believe the defense counsel has acted in a professional, ethical, and upright manner, but that was left to the defendant to submit to the state, and it was not properly submitted. It wasn't completely submitted.
Okay, I'm going to add that. Go ahead. You can move on to the next one. That's a yes.
And then the other thing is that the obstruction charges, I believe that both of them should be individually entered as guilty pleas because there were two officers, both were given instructions, and he could have at any point in time avoided both or at least one of those charges, and he didn't. The state would like to tell the court that I believe, including his original incarceration, that the defendant did serve 54 days in jail. And the state would also like to add that that really didn't go for his original charges. That was really for his additional charges of not complying to each and everything that he was asked to do.
Okay.
And so while the state is not opposed to him getting time credit for that, we would like to point out that that was of an entirely different manner of his misbehavior.
I agree with that. So, okay, anything else?
No, other than the state would defer to the bench for ultimate sentencing, but I do believe that with all of these guilty verdicts, which could have been resolved much earlier in the case, and the state was always willing to do that, that there should be additional time in jail to be served.
Okay, thank you. All right, Mr. White, I'd be happy to hear from you. And you're welcome to move the podium around if you want.
Your Honor, first I will say, of course, I do agree with the state regarding the DUI. The DUI has mandatory minimums on it, and they must be sentenced as a part of the sentence. Of course, we would have no objection to that. Regarding the other sentences, I know the state has made mention of potentially additional jail time. I do agree with the state. I do believe Mr. Stringer has done about 54 days in custody. I do understand both the state's assertion of, well, it's not even an assertion at this point, the state's a recounting of the event showing that it was a situation where Mr. Stringer was further placed in custody due to actions technically outside of this case. However, I will just point out that, of course, those 55 days, they were served, of course, in the Spalding County Jail, and they were done as a result of his bond in this case being revoked. So while I do understand that they were outside of the scope of this case, they are technically also a part of the case due to the fact that it was as a result of his bond being revoked. So, of course, I would simply ask that he be credited for that time. Your Honor, I haven't had as much time to talk and discuss things with Mr. Stringer as, of course, as you and the state have, as you guys have been on this case much longer than I have. I do believe that, but however, in the limited amount of time I have talked with Mr. Stringer, I do believe that while to an outside perspective, and potentially a lot of people could even agree with, he may seem like he doesn't necessarily have a respect for authority or something like that. But I believe that Mr. Stringer is more so of an impassioned individual. And I believe that he takes great pride in trying to work these cases out. That's why when situations where he felt his attorney was not doing a good job, he fired them and at some points handled it on his own. I believe that is due to a passion, but not necessarily due to a lack of respect for authority. And I understand the state may disagree and even the court may disagree, but from talking with him, that is why I believe that comes from. So, Your Honor, I would simply be asking that, of course, for the DUI, the mandatory minimums be given, and that for the remaining time, that, of course, he be given some form of probation. He'll have to be given probation to, of course, do the mandatory minimums on the DUI, and that for any remaining jail time, he simply be given credit for the time he has already served. Thank you,
Okay.
Your Honor.
And if you'll just talk to your client and see if he wants to make any statement before I sentence. I'm not suggesting he should or shouldn't. I'm just checking the boxes here.
Yeah, I'll make a statement.
All right. Do you understand you're under oath? You're not going to be cross-examined, but you're allowed to make a statement, okay? All right. Yeah, you're going to need the mic. So why don't you come up to the podium here and use that mic so Kathy can hear you nice and clear. And again, it's a statement under oath, but there will not be any cross-examination.
Yes, Your Honor.
All right, go ahead.
I do understand this is a difficult process. Yeah, it's in no way was I trying to kind of go against any rules or go against authority or anything like that. You know, it's been a difficult process to figure out. A lot of you know, trying to do things the right way, and it's trying to navigate that in the best way that I could. I understand now that, you know, what I may have thought was the right way may not be the right way, and other people view it as that. So I see this as an enlightening experience in which where I thought things were difficult, so I had to do it a certain way, it may be incorrect. And I do see that now. So if, you know, with these things coming to light, I do apologize for, you know, any stress or hard time I've given anybody. And I do apologize for that. So for this time, and I guess I'm sorry that this is the way that I apologize to you for this, the way that I had to find out. So
thank you. You may be seated. Okay, any other housekeeping from the state? I assume that this was a second and 10 DUI or something, y'all would tell me. Otherwise, I'm treating it as a first and 10.
This is the first conviction.
Yes, I caught that. So, okay. All right, so here we go. Mr. Stringer, before I announce my sentence, I feel I try really hard not to give big speeches before sentencing, but on this one, I have to fill in some context here, which is that you're kind of apt in your point, which is that because of your actions, your case has taken a massively oversized space in my docket, in my personal, not personal, but in my professional time off the bench, having to draft order after order after order on, frankly, some of which were legitimate motions, most of which were gobbledygook that was clearly created by AI because it said at the bottom, created by AI, and here's what you should do when you go to court. And so, am I against AI? No, not at all. I use AI extensively up here to double check everything I do. So this is not an anti-AI thing. What it is, though, is an anti-time wasting moment because you have the right to advocate for yourself. You have the right to have an attorney. You have the right to represent yourself. You have the right to do all of those things, and you decided that you wanted to do all of those things. And so I was constantly trying to just simply get your case moving forward towards trial, but I'm always having to pivot and deal with something else. You filed a notice. So obviously from the start, we got in, you got the public defender's office. I have the best public defender's office in the state of Georgia. I would challenge any judge to come in and say they have a better public defenders. I have Harry Charles in my office, capital defender for decades. The man has forgotten more law than everyone in this courtroom combined will ever know. That man knows what he's doing, and you fired him summarily because he agreed to a continuance, which made no sense to me. You literally threw a gold ring in the trash can because it had a little chip on it, instead of communicating with him and trying to figure out, is there a pathway forward? So you demanded to represent yourself. So we all stopped, had to repivot. You and I had to have a hearing where I had to put all that on the record so that you wanted to represent yourself. And I think we've got it settled and we're moving forward. And next thing I know, you've hired Dwayne Singleton. Again, top tier defense lawyer here in Griffin. And and they're in here all the time. And I, again, said openly, I'm very excited about this because when you're representing yourself, you bring a lot of chaos. You're filing all kinds of stuff. I can't keep up with what's going on. I'm having to draft orders after orders after orders to keep up with all the random filings that are frankly unnecessary. You demand a Brady hearing and accuse the state of withholding evidence when frankly we hadn't even come anywhere close to a deadline for discovery. So we were months away from any deadline discovery, and you were just insistent that I should dismiss the case. And I kept saying, that's not it. And so you said, well, you need to watch this video. And so then you released Dwayne Singleton's office. You're back to representing yourself again. We have to have another hearing on that. And after that, we end up having that hearing and you tender into the record the video. And you were saying over and over, Judge Thacker, if you will just watch this video, you will dismiss my case. You will have no choice but to dismiss my case. And so I said, okay, I will watch the video. This is a Brady motion, and I will rule for the sake of just this discussion that not that the state was withholding, but that I will watch it. And obviously, if it's exculpatory, I will take action on that. And you've quoted me several times in your subsequent motions on that before you got, frankly, who has been a stellar attorney. So you should know that your attorney did a phenomenal job for you. I could not be more impressed with Mr. White's professionalism, his competence, his demeanor. I thought he made a great job with the jury. And so I hope Mr. White takes 100 cases down here. And I thought he did a great job in what was a very difficult situation because in the middle of all this, obviously you went to the clerk's office. They were giving you very clear, very simple instructions. You had not released Dwayne Singleton. You were trying to file a physical item in the clerk's office that you weren't supposed to file. They were not totally against the idea, but the people that needed to make the decision on that were not here. And so they said return Monday. Well, return Monday just means return soon. It wasn't like if you don't come back Monday, you've lost your window. But you're the one who recorded it. I say secretly because you're legally allowed to record it. You can record in public spaces, but obviously you didn't say to them, I'm recording it. You and I both know this conversation is being recorded. This conversation will be turned into a transcript, and this conversation will be filed in the clerk's office. But you didn't give them that courtesy. You secretly recorded them. I don't know what you were hoping to gain, but all that you gained off of it was to provide me with another recording of you doing something you thought would be helpful, but that was ultimately damaging to your long term. Because she very clearly, and by she, I mean Miss Evans, very clearly was saying to you, the people that need to make this decision are not here. Could you please just return Monday? And your response was a very emphatic, you do whatever you want to do, I'm leaving it. And I heard her on the audio calling after you as you left and you ignoring that. And then when she came in here, because I heard about it and then I had to deal with it, and I'm the one who had to schedule the contempt hearing, you aggressively cross-examined her. Aggressively cross-examined her. The poor lady whose only job was to greet you at the window and try to help you sort out your mess. And you took zero responsibility. At least that's my memory of it. The transcript's in the file. We'll all look at it. And if I'm wrong, I'm wrong. But what I do remember is that you didn't come in here and say, Judge, I should have done that differently. What you did was you shifted it to her and you attacked her. So the disruptions you have caused are infuriating. And then obviously when the state brought in that other act evidence, I was like, oh my gosh, there really is a pattern here of you saying, I am trying to comply with what you're doing while absolutely physically not complying. You did it on the video here. You did it in Brookhaven. You did it in the clerk's office verbally by saying you're trying to comply when she's telling you, I just need you to come back Monday. So that's my point, is that I don't know you and you don't know me other than this terrible moment in your life. I don't know if this is who you are or if this is the moment that I'm just seeing you at your worst and you're passing through to something better. I am hoping beyond all hope that it is the latter. You are still a young man. You still have time to make, and they hear me say it here all the time, the next right decision. It's always the right time to make the next right decision. But you just put us through this trial after the state made a straight probation offer to dismiss some of the charges and really, honestly, give you minimal supervision and the ability to go back. And you rejected that. We had to try this case. And again, your attorney did a phenomenal job. But at the same time, after watching that video now, probably for the 18th time, because as you know, I watched the video a bunch to issue my Brady order. I didn't have any questions about what happened. That video, Deputy Carr's body camera video, told me everything I needed to know. Because when they were asking you questions, you gave them vague and non-committal answers. And when they asked you to get out of the car, you didn't. All that had to happen at that moment was for you to get out of the car. The fact that two highly trained police officers who were both pretty big guys and putting all of their weight, one of them even had you by the hair and was pulling, I think I saw his foot on the side of the car, pulling the top of your hair with every ounce of his being, while you saying, I'm trying to get out while not getting out, was one of the most disorienting moments of my career, where I'm like, hold on, the guy's saying he's trying to get out. But how in God's great green earth, when you got Deputy Carr, who's a big, strong guy, pulling you as hard as he can on one arm, and you got Lieutenant Strock with his foot up on the car, pulling the top of your hair, which had to hurt. Could they not get you to literally just stand up out of the car? Which told me that you weren't getting out of that car. You had no intentions of getting out of that car. And that's what I'm trying to figure out. Is that who you are? or was that the moment that we passed through? So if that's who you are, then my sentence is 48 months to serve. It's really simple. Like, why would I put you on probation why would I put you on probation if that's who you are? If you're just that person who is just absolutely not going to comply, you're not going to do what you're supposed to do, you're not going to listen to anything. It's really simple. It's 48 months. Because I am going to say that the obstruction charge 6 merges with 5. If the 2 of them had taken turns, just to factually distinguish why it merges versus why it doesn't, if Deputy Carr had pulled and then let go, and then Strzok had stepped in and pulled and then let go, and they had separate turns, then it would have been 2 separate charges that did not merge. But they were both pulling at the same time, making it one act, making 6 merging into 5. So my final thought on this is, I hope you will not make me pay for this, but I'm going to be a bit of an optimist. I'm going to hope beyond all hope that you are going to become the person that you want to be, the person that I do think you have the ability to be, but you're going to have to do the hard work of personal growth to get from here to there, because the choices you're making right now are not going to make your life any harder. And I need you to know that part of what I'm about to do is going to have jail time. So Piper, you can go ahead and put cuffs on him. You can cuff him the front or back, whatever you prefer. Okay, they're not comfortable, but you good? I mean, obviously they're not comfortable, but they're not too tight or anything. All right, you can grab a seat. I need to acknowledge that I just told the deputies to put handcuffs on you in front of your mom. I'm feeling that. I need to acknowledge, I, Judge Thacker, am feeling that moment that I just told the deputies to put handcuffs on you in front of your mom. And I'm about to send you to jail in front of your mom. But I need you to hear me say, I am saying that to you so that you'll remember this moment. And you'll also remember me saying, it's never too late to make the next right decision. This is your moment when you finish with this to make the next right decision. Okay? So here's my sentence. On 25 SR 0282, count 1 DUI, it is 12 months to serve. There's no fine. You will receive credit for the 54 days that you have served. Is 54, right? Okay. You will receive credit for the 54 days that you have served. Count 3, leaving the scene of an accident. The jury found you guilty. That is 12 months probation. That is consecutive, of course, to the jail time. $750 is your fine. Count 4, failure to maintain lane. That is guilty. That is 12 months probation consecutive. $306 is your fine. Count 5, obstruction, which count 6 merges with count 5. That is also guilty by the jury. 12 months probation consecutive. $1410 is your fine. So that's a total sentence of 48 months. It's 12 months to serve in the Spalding County Jail. Now, how much are you going to serve that 12 months? No idea. Don't care. That's between you and the sheriff. You've already been classified as a trustee out there. And so I'm factoring that in, that you will probably be reclassified as a trustee. While you're on probation, you may work off your fine with community service work. You will follow the general conditions of probation in that you will report as directed. You will not violate any governmental laws. You will not change your address. You will waive any extradition requests. You will work faithfully at a suitable and stable employment. You will avoid people and places of disreputable character. You will have no affiliation with any gang units. You will interact courteously, respectfully, and truthfully with all court personnel. I cannot tell you how important that line is for you personally and how little it will take for me to use that to revoke your probation. So I'm going to read that one more time to make certain we are on the same page. You will interact courteously and respectfully and truthfully with all court personnel. You will submit to a and seizure of your personal property by any law enforcement officer or sentence enforcement supervisor. You'll pay a monthly supervision fee. You'll pay an intake fee. And there's no early termination. You will have no alcohol, illegal drugs, or hemp products. You will present a Georgia license to the sentence enforcement team within 24 months of when you start. So I guess it's actually 36 months from the actual start. I'm going to make that 36 months. You shall report to the Sentence Enforcement Office in person within 3 days of your release from the Spalding County Detention Center. This one goes to the state. Because there may be restitution, I'm going to put that Charles Davis has restitution of to be determined. And I'm going to put that the state has 90 days from today to get a consent order or to request a hearing. So if the state does not request a hearing on restitution to the victim within 90 days, then that closes and there won't be any restitution or hearing. 40 hours of community service work at no less than 6 hours per week. You will, within 90 days of release, complete a substance abuse evaluation, as well as an anger management evaluation. You'll complete 20 hours of you'll do a 20-hour DUI school, as well as the appropriate anger management courses. You will have no access to firearms or ammunition. This entire sentence is in person. This entire sentence is zero tolerance. Zero tolerance is a local term that we use here in Spalding County. And the way zero tolerance normally works is it's normally my last ditch effort to try to not put someone in jail who has already done all the things that they are not supposed to do. And I'm just saying, hey, I'm just going to give you one last chance. Well, you've already used all your chances with me. And so I'm jumping forward to, I'm just putting you on zero tolerance. So if you come down and you step out of line, even an inch, I'm going to take a warrant. I'm going to grant a warrant first, and then I'm going to figure it out second. Now, I have intentionally carved this so that it's harsh up front, because I need you to understand that I'm not messing around anymore. Okay? You just put us through this trial. You have a constitutional right to a trial. You have the right to appeal this decision. You have 30 days from today if you want to appeal this decision. If you do decide to appeal this decision, and if you do decide to keep Mr. White, Mr. White will be able to get in touch with Kathy, request a transcript, and you will need to pay for that transcript. So I'm just letting you know that if you do file a motion for new trial or an appeal, which you can talk to Mr. White about, that will not get lost on the docket. So I'm not a Metro Atlanta court that loses track of things. We know exactly where everything is in this court, and we know exactly where it's going. But I will say that, like, it was frustrating to me that, like, you filed a notice of appeal on your contempt hearing, and despite several moments from me where I'm like, hey, here's how you move your appeal forward. Here's how you get your appeal to the Court of Appeals. I welcome a review from the Court of Appeals of the decision I made, even if they tell me I'm wrong. And you took no action whatsoever, despite written directions and verbal directions and everything else. And I ended up dismissing that appeal. So I'm just saying, if you want to appeal it, appeal it. If you don't want to appeal it, don't appeal it. But either way, I need you to hear me say, as I finish this up, I do think you have, I really do. I mean, just to take the judge robe off for a second and just be very transparent, I think you have an amazing future. You're bright. You're articulate. You could have an amazing life. And it wouldn't take a lot of effort for you to pivot and grasp that life. But you've already told me you got 6, 7, 8 cases floating around everywhere. I mean, that's not normal. And so I'm saying to you that you're either going to keep driving cases or you're going to make better choices, or, as I like to say, the next right decision. And then you will get to live the life that, frankly, you deserve to have. And then I think you're capable of. And I really hope Director Matthews lets me know that you are rock starring it, and that all of those skills and brains you have, you're putting to good use. and getting your life back on track. All right, that's it. Anything else from the state?
No, Your Honor.
Anything else, Mr. White? 30 days to appeal. Court's adjourned.